Hi, my name is Nur Lyana and I'll be Mrs. Balfour and Mrs. Merrit.
Hi, good evening everyone. My name is Nurhuda Dini binti Rizal and I act as the husband of Mrs. Merrit and Mrs. Balfour. Hope you guys enjoy the tea.
Legal principle in this case are intention to create legal relation in the case of domestic agreement. So the general principle is that parties did not intend to enter into legal relation unless there are positive evidence that the parties intended to have relationship. Contract Act 1950 have been silenced and there is no provision, so we applied common law. So let's take a look at the cases.
The question is whether there is any legal binding between both parties.
And Mrs. Balfour were married in 19,000. They spent the first 15 years of their marriage in Ceylon, where Mr. Balfour was employed as a civil engineer. The Balfours were in England from November 1915 to August 1916 on vacation.
Mr. Balfour, I think you need to stay here for your further treatment on your rheumatoid arthritis. Sure? Thank you. Every month I give you monthly allowance for about £30, I think. So don't you worry, okay? Take care there. Bye.
Alright, bye. You too. It's been a few months since we broke up our marriage, but he did not give me the allowance for a long time. It is unfair. I think I have to file suit against him.
The Court of Appeal would like to reverse the previous trial which the plaintiff, Mrs. Balfour, wins because we think that there was no enforceable contract between the Balfours and it was merely an ordinary agreement made between husband and wife. There was no intention to create legal relation and Mrs. Balfour cannot sue for the breach of the contract. I, Lord Justice Atkin, thinks that there was no intention to create legal relation between husband and wife because nobody would think that in the ordinary circumstances of agreement that there will be any legal consequences and inevitable for husband and wife to make an agreement because of their close relationship. The domestic agreement is not a contract because both parties did not intend to have legal consequences, and if it is, then the court will not be able to handle many cases happen between husband and wife. So the onus of proof is on the plaintiff, Mrs. Balfour, but the plaintiff did not rebut the presumption. Therefore, the court thinks that there was no intention to create legal relation and there was no contract made between the husband and wife at all. Appeal was allowed and the court is dismissed.
In comparison to the next story, whether the parties have intention to create legal relations.
Mr. Merrit and Mrs. Merrit married in 1941 and they had 3 children.
However, the husband became attached to another woman and left the matrimonial home to live with her.
Wait. Before that, I want you to write this on the agreement. In consideration of the fact that you will pay all charges in connection with the house until such time as the mortgage repayment has been completed, I will agree to transfer the property into your sole ownership. That's all. Thank you. In the following months, she paid off the mortgage, partly out of the husband's monthly payment to her and partly out of her own earnings. I already paid off all the mortgage payment of the house. You have transferred the house to me, as you said before.
I have made a decision and I think I don't want to transfer
But
my house to
why?
you. Why not? I don't want to give my house to you.
On behalf of the plaintiff, the wife, the property should belong to her, and the defendant, as the husband, should be responsible to make the conveyance for it.
On the other hand, the husband counterclaimed that the property was owned by the parties in equal shares, and the agreement was in certainty because of the arrangements for £40 a month maintenance that is obviously attainable. Therefore, I shall declare that there was no consideration for the agreement.
In the case of Mr. and Mrs. Merrit, the court held that the agreement was binding and there is an intention to create legal relation. Although the general presumption of domestic agreement is that both parties did not intend to create legal relation, however, in the case of husband and wife who was about to separate or is separate, then the agreement is intended to be in a legally binding contract. The agreement was enforceable and Mr. Merrit promise was ample consideration for Mrs. Merrit to pay for the mortgage and Mrs. Merrit entitled to the marital house. The Court of Appeal would like to distinguish the case between Balfour and the Merrits because the Merrits husband and wife are both have separated or was about to separate. So when they come to an agreement, then both parties intended to create legal relation. The written agreement also further stated as an evidence that both parties really intend to create legal relation for the house. Also, changes in society, which is Balfour case is in 1919 and the Merrits case is in 1917. Changes in society state that it is normal for husband and wife to create an agreement which intended to have legally consequences because of the time has changed and husband and wife are more open in those days. Therefore, the court did not allow the appeal by the Mr. Merrit and the court is dismissed. The case of Balfour and Balfour shows that domestic agreement did not have intention to create any legal relation between husband and wife. In the case of 1969, Gold and Gold have also used the principle in Balfour and Balfour where domestic agreement indicate that husband did not objectively intend to be legally bound. Also in the Singaporean case of Chow Tiong Hin and Chow Hock Swee 1959, Balfour can also be applied not only on husband and wife agreement but also in the family arrangement between father and son. Because the agreement between family is actually outside the realm of contract and therefore the parties did not intend to create any legal relation at all.
However, there is a rebuttable presumption and exception in the case of Merrit and Merrit where it established that the onus is on the party alleging that a legally binding contract exists to rebut the presumption. The court distinguished the case of Merrit and Merrit from Balfour and Balfour that on the fact that the Merrits, although they are still married, were estranged and separate at the same time when the agreement was made. Therefore, the agreement was an intention to create legal relations. The decision was made half a century after Balfour and may reflect changing social attitudes to the position of women in the society. The case gives us authority to look beyond the marital status on the parties and consider the contextual details. The same decision of the case Merrit and Merrit was later applied in the case of Petit and Petit, where the facts of the case is similar to Merrit's, and the court held that the husband had no equitable interest in the matrimonial home if the husband and wife were divorced.
In the case of Balfour, in accordance with Islamic perspective, one should fulfill their promise when they make one. One of the characteristics of hypocrite, which is munafiq, is when promising something, the party shall fulfill his promise and not breach it. Shown by a hadith narrated Abu Hurairah, the Prophet said, The signs of Munafiq are 3. Whenever he speaks, he tells a lie. Whenever he promises, he always breaks the promise. If you trust him, he proves to be dishonest. If you keep something as a trust with him, he will not return it. Another narration adds the words, even he observes Sawm, performs Salat, and claims to be a Muslim. Therefore, the husband, Mr. Balfour's action of breaking his promises to his wife could be considered as a hypocrite act, and it is despised by Islam.
Conclude, in comparison for both cases, the decisions made by the court were different, as the facts for both cases is not similar in terms of their relationship. For the case of Balfour and Balfour, the couple still in relationship even though they are not living together. While for the case of Merrit and Merrit, they were separated. It shows that same principle cannot be applied as they were not in amity.